Good evening, everyone. This is Rakhi Gautam from greytHR. I welcome you all today to the Thought Leadership webinar, greytHR Meets. First of all, I'm happy to announce that greytHR has teamed up with A6 Middle East, the master distributor for the Matrix Attendance Management solution in the Middle East. The goal of this alliance is to leverage each other's expertise and empower more organizations in the region by offering them integrated HR solutions. And as part of their strategic initiatives, greytHR and A6 has brought together this webinar to you today. As you all know, the topic for today is navigating the new UAE labor laws, its impact on employees and employers. Now, before I dive into the topic, let's do a little housekeeping on how the session goes. So the session is divided into two parts. The first part will be the discussion with our expert, which will then be followed by an audience Q&A. So audience Q&A is where time is all yours. You can start putting across your questions and we will take them up towards the end. Also, the session is currently being recorded. So if you happen to miss out on anything, do not worry at all. We have got you covered. We will share the recording with you after the session is done. Also, this session will be available on our official greytHR YouTube channel under the playlist greytHR Meets. So you can always go there and watch it again. Now, we have the quorum to start the session today. So without any further delay, let's get into it. Over the next hour, we will be providing a clear picture on the new UAE labor laws. We will explore how they affect both employees and employers, from new benefits granted to workers to the updated responsibilities based on businesses. We'll also delve into how these revised laws impact recruitment and conflict resolution. By the end, you will be equipped with the knowledge to navigate this evolving legal landscape and ensure compliance. Now, to decode all of that and to share his knowledge and insights with us today, joining us is Ahmad Khalil, partner at Crimson Legal. Let me quickly take you all through his profile. Ahmad is a seasoned lawyer with over 20 years of rich experience in both contentious and non-contentious legal practice, spanning reputable law firms and multinational corporations. His expertise covers a wide spectrum, including M&A, corporate law, technology, employment, criminal claims, and real estate across the GCC and the Levant areas. Holding degrees in law from the University of Bristol and an MBA from NYIT, his core competencies include drafting and negotiating various contracts, corporate structuring, litigation management, regulatory compliance, and adapt mediation. With a track record of navigating complex legal landscapes, he provides invaluable counsel and resolution for diverse client needs. So I think we've gotten the perfect person today with us to join us on this session. Once again, welcome, Ahmad, and thank you so much for joining us today.
Thank you for having me. As always, Rocky, I appreciate it. Thank you.
Thank you so much. So now, before we start with the questions that I already have with me, let me launch a poll for all of you audience today. This is to understand your perspective and your interest as to what is it that you are looking to get most of from this session. Let me quickly launch the poll. Give me a moment. Okay, so I have launched the poll question. Of course, this is not a right or wrong question, answer question. This is more like to understand your interest as to what you are interested in learning about. So I would request all 71 who are present here today to participate in this and to help us understand your perspective. Okay, 50% down, 50 more to go. To all of you who haven't chosen the MCQ that's displayed on the screen, please do that, and we will quickly start with the questions then. Okay, I think we have the quorum with us. I'll just quickly end the poll and also share the results with all of you as to what all your peers are looking at, learning today. So there's benefit for employees, that's 33%. Responsibilities for employers, that is 46%. What I can gather from here is a lot of employers are joining us today in this session, and they would want to know more about how this is going to impact them. Then there's also impact on recruitment and retention, and a little 4% of conflict resolution procedures. Okay, so thank you so much for to everybody who participated in this poll. This helped us gain your perspective a lot. Okay, so let me start with the first question, Ahmad, to you. Starting with a very basic question, which is also the most important question. Please elaborate on the most significant changes introduced in this new UAE labor law for both employees as well as employers.
Okay, thank you, Raki, for the introduction and for the poll. It's interesting to see that, like you said, most of the attendees are on the employer side, not necessarily on the employee side. But in any case, I think the most significant, for me at least, the biggest change is the fact that they have removed the concept of an unlimited term contract. So back in the day, we used to have limited term contracts and unlimited term contracts, and each one had its benefits and its and the negative sides. In the new law that was introduced, they removed unlimited. Everybody is on a limited term contract, be it 1 year, 3 years, and now they've opened up to even 10 years, as long as there is a starting point and an end point. That's the most important one. So from my perspective, it's both a good thing and a bad thing. And I'll go into those details later on when the questions start rolling. But I think that's the most important one I've seen so far. And we get asked about this quite a lot.
Okay, thank you so much, Ahmed, for setting the context and telling us the most significant change that's happened with this law. Moving on to my next question, which is, are there any specific industries or types of employment contracts, as you mentioned, that are more significantly impacted by the new regulations?
So in terms of industries, I mean, paving the way post-COVID to more people working remotely, more people wanting to do freelance work than ever before, with the addition of several types of contracts. So you've got full-time, part-time, even for underage, they have some form of contracts. I think what has been introduced has been very welcomed by the community because of the fact that they are now able to select from various types of contracts. So I don't think it impacts any specific industry unless you are services that can operate remotely. So a lot of the times we have now clients who are coming to us with, they have an employee who is sitting in Jordan. They want him to be an employee, but they don't want to go through the issues of visa requirements and immigration. So with these contracts, they do get benefits out of being employed outside. They don't get all the benefits, but they can opt into them. So I think as far as an industry is concerned, it didn't change for one specific industry more than the other. It's just the fact that there is a lot more leniency with the options that are available to everybody who wish to either employ somebody or are looking to be employed and have a more flexible option for them.
Okay, so what I can understand is the new changes that's brought in the labor laws have brought more transparency, more flexibility, has given the employees more chances and options to explore.
For both, I think for both of them, because not every company wants a full-timer. They want part-time employees. They want working from remotely. So this paved the way, and I do think it was a step in the right direction because it's giving both employer and employee more options to think about rather than this is one cookie cutter. Everybody has to fall within that one scheme.
Definitely, I think this is going in alignment with what we say a modern workforce today. for both employees as well as employers. So thank you, Ahmad, for sharing that. Moving on to my next question, which is more specific to employees. So can you explain us in detail about the new benefits which would be granted under the updated regulations?
So the updated regulations, one of the most important points from an employer and an employee perspective is clarity. So based on the old law, the definition of basic wage was different than the one under the new definition. So, for example, calculating end of service. When you now come to calculate end of service, it's a very clear-cut situation of what that entails and how you calculate that. Back in the day, we used to look at the courts to give us the, the meat on the bone, to explain what was needed from the law in form of precedent and the court system. They've definitely looked into more on the so the clarity is the most, I think the one that I would say is the most important one. They've also looked into how can we retain the employees. So you're talking about, giving them options of this didn't come through the law, but this came after the law. For example, the employee unemployment scheme. So for the first time in the region, you have something that is called an unemployment scheme, which means that employees, should they lose their jobs under certain circumstances, can still earn a wage. Granted, it's not the full wage, but something has been given to them. And that's some form of protection that the government is affording. So the benefits have become more interesting. Some of them have gone backwards. So, we talk about in the old law, you talked about arbitrary dismissal and compensation. The new law does not have this concept at all. So it depends on which side you're sitting on. If you're an employer and you're terminating, it's a good thing. You don't have to compensate for dismissing a person for reasons outside of the law. On the employee side, if you're terminated unjustly, you get some form of compensation. So it's a double-edged sword. It depends on who's looking at it and who will benefit from it. So there are various elements to it. I think another important one is the fact that they've started, this small claims tribunal for matters that are less than 50,000 dirhams, for example. This is a major change. Again, it's the first in the region, whereby employees who are claiming for less than 50,000 dirhams can get a judgment through the ministry itself rather than go through the court system. So you don't need lawyers, fees are minimal, and it's a very quick turnaround. So I think when the law was initially introduced, we had a lot of questions as the legal community. But as time went on, as the courts clarified more, and as more improvements came about, definitely, it is a step in the right direction, at least from our perspective, we believe.
Definitely. Thank you for that, Ahmed. And I came across this news when it was announced that this uh, unemployment insurance are now given to unemployed persons, which is actually a very huge decision taken by the government, which I think a lot of us would agree with, because this isn't something casual that you say, okay, this is something that we are giving. This is a huge moment. So definitely, it's a step, I think, in the right direction for the employees, for sure. For employers, as you said, there are two ways to look at it. There are two sides. It depends which side you're looking at from. So thank you for that, Ahmed. I'm moving to my next question, which is for employees. So how will the new minimum wage requirements be implemented now? And are there any resources available to help companies comply? Because given that there have been so many changes made recently, how do we know, okay, which is the right platform to go for to get the right information? How can we comply with all these rules? So any tips and suggestions for the employers?
So on a general scale, the law doesn't get into too much detail on the minimums and all of that. You have to maintain some minimums from an immigration perspective, for example. To sponsor a family, you have to have a certain minimum, and I'm trying to think what that minimum was. I think it's either 2,000 or 3,000 dirhams per month as a salary. I need to double check that, but there is a minimum requirement for visa rather than for employment. Now, if you look at the basic principle of contracts between an employee and employer is it's whatever you two agree to. That's the basic principle. So it's an offer and an acceptance. If the employee doesn't like that amount, then you can choose not to work with that particular company. Same still remains still today. You have real estate agents, for example, who are on minimums of, I think their basic salaries or their written salaries are 1,000 dirhams. And this is what we're normally talking about, is about 1,000 dirhams, so that you can make sure that things are running a little smoother with the bank, with the employers, for the WPS, so on and so forth. There has to be some definition. That's the requirement. Now, in terms of what, for example, is considered market practice, or in certain industries, what is considered, um, LinkedIn is a great tool to find out about, these market studies. You have all these companies that do market research. They will be probably the best resource for such information. The ministry, I've found, we've spoken to them a few times, will not give you a solid answer. They will say that it's whatever you two agree, but we recommend, like 1,000 or 500 or something of the sort. So it depends on the industry. It's different, for example, for domestic workers and laborers versus, CEOs of companies and other employees and everyone in between that scale or spectrum. So I would be worried about somebody giving you a solid answer to what is that bare minimum, but the recommendations are that the sources are out there. You do a little bit of research, you can get some form of market research about what is required.
Okay, thank you for that, Ahmed. Moving on to my next question, which is, what are the specific changes, regarding employee safety standards under the new law, and what are the implications for employers who fail to comply with it?
So I think in terms of the safety, the most important one is the discrimination article that they put into it. I mean, there were provisions in the old law. There are provisions in the penal code, in the civil code, and so on and so forth. But this time around, it was written with clarity, and it was written specifically for anti-discrimination. So anybody who feels like they've been discriminated against and have suffered because of it, they have methods of or a procedure to follow now with the ministry directly. So in terms of, because I mean, we face this with a few of our clients where employees felt threatened by their superiors, for example, because it's a position of power. If you go and tell on a senior, they will retaliate. So with one of my old company, they had an anti-retaliation policy. For example, this is protecting employees from, individuals in more powerful positions from taking advantage of that position. So it did provide further information. So even the implementing regulations go into the safety and health and specifics. They talk about, penalties to employers, financial penalties and or otherwise. So they've definitely made, again, I go back to the same point, clarity. They've clarified what happens to entities or employers in case of non-compliance with the thresholds, the safety and health measures that are required from that specific industry. So again, it depends on the industry itself. Manufacturing has far higher safety and health measures, whereas us lawyers, we're sitting behind a desk, we're just typing away at a computer. The anti-discrimination clause is the one that springs to mind and is the most vital out of everything that's come out in the new law.
Okay, so I think we can, safely say that the new changes that's been brought, it's also made, things more. The decision is that okay, things are now more fairer. There's more transparency, and it's again, I can't say that it's more towards the employee side, but I think a lot of positive changes have been made, which will positively impact the employees who are working with, the
Yeah.
organizations in the past.
I think
Okay.
again, Raki, it really depends on which side you're standing on, because either way, look, the law is the law. We always say this. The intentions are always noble,
Mhm.
but when you write a law, there's always going to be black and white. Which side are you standing on? So it's fair to the employer on some parts, it's fair to the employee on others. So it depends on which one you're looking at. But again, the whole point of the legislation is to try and make it as as fair as possible on everyone across the board. And
Definitely.
I think with this one, they've done it a little better than the old one. There are still a few things that we would think should be changed, but I think that will come with time. Maybe the courts what's it called? Will make sure that these are applied.
Definitely, one step at a time.
Yeah.
Okay. So before I move on to the next question, there's one poll question that I would want to launch for our audience here, which is again to understand how this new changes will impact your company's recruitment strategies, if you feel that it will. So I'm just quickly launching the poll. I would request everybody to participate in this and help us understand your perspective.
Mhm.
Also, at the same time, keep the questions coming in. We would be happy to take them up towards the end of the session. So as many questions as you have, please shoot in. We'll try to cover as many as we can within the time frame. Okay, 50% of you have participated. The rest of the 50%, please. Do you believe the new labor laws will significantly impact your company's recruitment strategies? Yes, it will, somewhat, not much. So considering that we have a lot of employers joining us today, I think all of you should definitely participate in this poll. Okay, I think we have the quorum with us. Some 72% of you have participated. Let's at least make it 75. The rest of you, okay, yes, I see the numbers moving. So, okay, let me end the poll and share the result with all of you. So it's a mix. There's 32% who say yes significantly, 39% somewhat, and 29% feel not much. Okay, thank you so much, everybody who participated in this poll. Now, my question is coming to you, Ahmed. How do you think the revised laws will impact recruitment strategies for businesses in the UAE?
I think the most significant change was the one relating to the visa cost and employment costs. So under the new law, they've issued a directive saying that if anybody resigns during their probation period, you as an employer have a right to go after their new employer for the visa costs or the costs incurred in employing this individual. So we've had certain clients or cases in the past where, they became like a landing pad for people to come from Europe, from Asia, from the Middle East. They just come in, sit for a month or so, find something that they really want to do, and just leave. In the meantime, the company would have incurred, possibly tickets coming into the country, visa costs, medical, insurance, so on and so forth. And under the old law, these were not recoverable. I remember even having discussions with our old clients saying, okay, can we mention that it's training? And if they leave early, we have to charge them for training. And the law, the courts would not have any of it. They would not allow any of those items. Under the new law, it says you can recover costs. Now, the definition of that has not been determined yet by the courts. At the very least, visa costs for sure, medical 100%. So it's direct costs. If you've paid, for example, relocation fees of 50,000 dirhams, that has to be the determination of the courts themselves. I would think it should be part of it, but the new employer should not be involved in relocation costs. This is something that was agreed upon. So sorry about that. So this would be the most impactful one, I think. So a lot of the employers are now in a bit of a better position because they know that if these people leave us during the probation period, we have some form of recourse. So maybe the recruitment becomes a little easier. It's just that they have the inconvenience of now going and following up with the new employer to get that money back. I think that's a significant change.
Definitely. Thank you so much for that, Ahmed. And do you think employment contracts that we spoke of in the very beginning would also, play some role, in impacting these recruitment strategies?
Sorry, your voice broke up. Sorry, Iraqi, again.
No problem. So what I wanted to ask is, since we are discussing about the recruitment strategies and the impact of these new laws on these recruitment strategies, we discussed about employment contracts in the beginning, right? So do you think that would also play a key role in designing recruitment strategies now?
I think so. I mean, look, the recommendation still remains the same as before, where you talk about a probation period. We've had clients ask us, should we give 30 days or should we give 3 months or 6 months? Our recommendation is always give 6 months, because that gives you enough time for you to validate whether this is the employee you're looking for. So in terms of the contract, that would be the important and crucial matter, is the probation period. It still is the same recommendation as before, use the maximum one. If you decide to fully and completely employ them outside of the probation, you can always tell them that irrespective of the probation period, we now want you to be a full-time employee. So you can do it, but the inverse is not possible. So it definitely, the contracts and the way they are worded now makes a bit of a difference. A lot more in terms of the recruitment, you talk about the confidentiality, non-solicitation of employees, of clients, so on and so forth. So the employees have the employment contracts now that are being drafted by the ministry are far more detailed, and they protect the employers far more than they used to in the past. So, but both of them actually understand right off the bat what their positions are. So whether you're an employee or an employer, that contract gives you all the information you need. You don't need to read the law to understand what your rights and obligations are on either side.
Okay, thank you so much for detailing that for us. Moving on to my next question, which is, now that we've discussed about the impact of, these laws on the recruitment strategies, if there are any, proactive steps or tips that you can suggest for our employers today that they can take to retain talent in this light of new regulations, what are the steps that can be taken?
Yeah. I mean, it's as simple as pay your employees on time. We have had so many cases of employees going and filing these claims with the Ministry of Human Resources and Amortization on delay in paying salaries. It's as simple as that sometimes. It's, I would say, one of the most recurring questions. I haven't been paid. What do I need to do? This is on the employee side. So that is, I mean, it sounds pretty obvious, but a lot of companies come in and say, well, they need us more than we need them. It's okay. We will delay it. We need the cash flow. So paying salaries on time, very important. Being clear and upfront with your employees. I think that's another important factor. If you don't want them to take, for example, vacation in the first 6 months, you tell them that you are not allowed to take it. Although it's written in the law and it's in the contract, be upfront and very clear with them. I would also say if you are the type of company that is very high strung in terms of deadlines, we normally recommend, for example, giving the employee, you recommending when you're going to give them the time off. So you tell them from June 5th till June 30th, you are off. This is your time. If you choose to stay in the country, you can, but this is their recommended. This is the time when you need to take it off. They already know at the beginning of their contract that this is when I'm allocated. So again, clarity. What other ones? We used to say commission and possibly bonus schemes. We've realized that money is not always the most important one. It's the corporate culture. So if you have a very toxic culture, 9 times out of 10, you become a revolving door, and the employees will not stick around as long as you would like them to stick around. So this is something I preached when I was head of a department in one of the old firms, is that the culture is far more important than anything else. You can pay them all the money in the world, but if they are a disruptor in the company, one rotten egg will ruin the whole basket. So the culture is a very important thing. I know it's not on the legal side, but it's something that I always preach to the clients. sometimes you can't help it. I'll be honest in saying that in certain categories, and I'll talk about the one I'm in, legal, for example, it's very cutthroat. You will have a culture of individuals who are, jostling for the top position because they want to get paid more, they want to be recognized more, and they want that position. It's how you manage that culture as management. I think that would be my recommendation to employers.
No, definitely a lot of insights you have shared. Great strategies. I mean, one thing that definitely stood out was the culture point. No matter how many rules and regulations you bring into the organization, you follow them as well. But until you create that environment, where people feel safe, where people feel heard, you create a culture where people can talk to you, come to you, and be transparent.
Yeah.
That is very important. And if you're able to build that kind of environment in your workforce, that takes you, to larger greater heights, I would say.
Yeah.
So thank you so much, Ahmed, for sharing that. Of course, and also I'm seeing a lot of people raising their hand. So if you have any questions, you can put that question in this Q&A option that you can see on your screen, and we'll just be taking them in another 10 minutes. So you can ask your questions there. Okay, moving on to my next question is, with the updated legal framework, what are the recommended avenues for resolving conflicts between employers and employees while ensuring compliance for both parties? I think this is also one of the questions that we got from the audience. So, please share some insights on that as well.
Yeah. So I refer back to the comment I made earlier. Based on the old law, and not even the law, the requirements of the ministry, it used to be that if you have a grievance as an employee, you would have to go and file with the ministry first and get a complaint number, and then they try to resolve it. If it's not resolved, it's transferred over to the courts. Now, the courts are inundated with cases. It's a slow-moving procedure, unfortunately. And more often than not, people are told to hire lawyers because you failing to ask for a specific item, the courts will not come and grant it to you out of the kindness of their heart, unfortunately. So you do lose out in that sense. Now, recently they've announced that any amounts less than 50,000 dirhams will be handled directly by the ministry. So you don't have to go through the court system. It's a much faster paced process. I think their target is within 30 days. To put it into perspective, court cases take anywhere between 6 months and a year, whereas with the ministry, it's 50,000. I think this is a great step in the right direction because of the fact that we are asked a lot of times that we have an employee who's owed 16,000 dirhams. It's not worth hiring a law firm that will cost them that much, if not more, to claim something that is the same value. So the procedure has changed. For anything less than that 50,000 dirhams, it has become a very good avenue for them to go and file these complaints, because you don't need a lawyer. All you need to do is present your, I think it's Emirates ID and your employment contract, and give a brief of what has happened. Both parties are requested to then discuss, and a decision is issued by them, which becomes final. So I think this is a great way for them to assist the employees and also the employers as well, because imagine somebody's asking for 16,000 and your lawyers will charge you 30,000 because you are an employer. So they're going to lose the 16 plus the 30. So it's a great avenue and a great process for both parties, I think.
Thank you for that, Ahmed. I'm sure that helped a lot. I'm moving on to my next question, since we talked a lot on the positive changes, sort of. But are there any gray areas or potential challenges that employers and employees both should be aware of, regarding these new labor laws?
So, I mean, it's not really a gray area. The law did handle it, but I think it's an item which we're constantly being asked about, which I referred to you before, which is the arbitrary dismissal compensation. So the new law does not have that concept. It's been removed with one exception, which is if the employee goes and files it's called a serious complaint, that's a translation in English, and you retaliate by terminating them, they're allowed to be compensated for such retaliation. That's the one situation. Now, based on this alone, we've seen employees being terminated and asking for arbitrary dismissal compensation. So the law, although is clear, there still remains certain employers or employees that believe that the rights based on the old law still apply. Till today, till last week, I was discussing this with the head of legal for one of the companies. He's like, what do you mean there's no arbitrary dismissal? So it's not exactly a gray area. It's just that the changes have come about, which not everybody is cognizant of. So they might have not been aware of it. Gray areas come in, for example, in what constitutes a serious complaint. So if I want to go to the ministry and say that, is discrimination considered serious complaint? Is failing to pay my salary for 3 days, is that serious complaint? So unfortunately, because the laws are made by man, there's always a room for, interpretation. And I think as we move along with the law and the implementation of it, the courts will get involved and they will start defining anything that has been deemed gray. So again, it's the same analogy of, the law is the skeleton, the courts and their decisions are the meat on the skeleton. So they define and they clarify any gray areas.
Definitely. Thank you for that, Ahmed. My last question to you would be, I think you did mention about it, but any resources that you would recommend for staying up to date on any further developments or clarifications related to these labor law changes, and or as you said, there is also lack of awareness amongst the people in the Middle East about these changes. So how can we stay updated? Are there any authentic websites, any guides that we can refer to stay updated?
So my greatest resource, apart from the official Gazette, is LinkedIn. LinkedIn is a great, great tool if you follow a few law firms, a few HR specialists, a few the even the National Gulf News. All of them keep continuously publishing articles. I've written about, I think, maybe 5 or 6 articles in the last couple of months just on the labor law. So these are constantly published. So HR companies or resources, corporate service providers, sometimes they do it, law firms or lawyers, individual lawyers, and LinkedIn in general. People do tend to put that information. Another tactic I used to use, but my email got inundated with it, is use Google tags. So you put in labor law, and every article that comes out will tag you and say, this article has come out. Would you like to check it out? So I still think LinkedIn is the better option. HR companies, they will continuously talk about it, and lawyers who are specialized in employment matters, they will definitely keep you apprised.
Definitely. Thank you so much for that, Ahmed. This has been a very enlightening and insightful discussion today. There were a lot of, I can't sum it up because there are too many things that we talked about. But great insights that you shared. You talked almost on all the significant changes that's been brought up with this law, and I'm sure this has been helpful for our audience as well. Now I see already some 20 questions lined up, so we'll just quickly take them one by one and try to cover them within the next 20 minutes. The first question is from Nikhil. What is the maximum duration of limited contract? 2 years or more more in one go?
So the law came out initially saying that it's maxed out at 3 years, but the immigration services did not allow us to do anything more than 2. So the law says one thing, the immigration says another. Now they've clarified, saying it can be any amount of time as long as it is determined. So you can do it 6 months, 1 year, 10 years. There's no fixed number as long as there is a start date and an end date.
I hope that answered your question, Nikhil. Moving on to the next question, which is, what if I'm an Emirati and being discriminated in my own country or working in a private sector by expats? As an Emirati, I've dealt with bullying, harassment, and rumors. What are the penalties for that?
So this is again on the discrimination clause, which talks about any form of discrimination. It could be color, race, nationality, physical abilities, mental abilities. It is pretty much an all-encompassing article talking about discrimination in specific. Now, the penalties for the companies are definitely financial ones. I don't know if they will go as far as shutting down companies, because that does not benefit anyone. Now, if you are feeling like you are being discriminated against, definitely go and file with the ministry. Have everything ready and prepared to show. Think of it this way: if you needed to present something, you have to think like a lawyer. What sort of evidence do I have? Some of the times I've seen it in the past where it's private conversations. You'd be sitting in your office, somebody walks in and starts yelling and screaming at you, saying, you person from this country never understand, your people don't understand, that kind of discrimination. It could be as simple as that. So if you have it in writing or you have witnesses, definitely go ahead and file it. You can either reach out to your HR, to your management, which might be the problem to begin with. So you can reach out to either lawyers or to the ministry itself, and they will clarify the procedure for you to follow if you're going to go down that path.
Okay. Thank you so
Yeah.
much for that, Ahmed. Moving on to the next question, which is this mandatory for any entity in free zone area in UAE to register their GCC national employees in GPSSA, or is there any exception to this?
So I'm not sure if in the free zones, I would think maybe apart from ADGM and DIFC, I think the rest would fall under the federal. I'm not sure what happens in those two locations. I don't actually have an answer for this one, to be honest. GPSSA, I don't know. I can find out, but yeah, I don't have the answer to this one, unfortunately.
No problem. So what we'll do, actually the attendee hasn't given their name here. What we will be doing after this session is share the recording of this session with everybody, all the attendees here today, with Ahmed's email ID. So if you have any questions or you just want to simply connect with him, you can do that through that. And we also have a knowledge sharing platform called Great Rep Community, which Ahmed is already a part of, where we have experts like, from we have employment lawyers to HR leaders, to industry experts who can guide you with any queries that you have. So you can sign up to that community as well, and you can get answers to your questions that you may have. Okay, moving on to the next question, which is from Jubu. One thing that they want to understand is on this you touched upon in your one of your answers. One thing they want to understand on the new recruitment from outside country leave soon after probation and the company end up paying huge amount on visa and ticket cost. I think they just want to understand what
Yeah.
can be done in this situation.
So this is one of those situations where the law was trying to be fair and grant employers some form of protection, but inevitably it didn't go that way. So we've seen it before on the same situation where it was a week after probation, the person left. Unfortunately, you cannot claim those costs back because the law is very clear. It's within the probationary period. So in that situation, you can try with the courts. I wouldn't try, to be honest with you. Um, you would pay more for the courts and the lawyers than you would under just taking that hit. Now, I'm not sure if this can be used under this new small claims procedure. We'd have to wait and see. I mean, we can try, but we'd have to wait and see if this will be allowed because, for example, these costs are more often than not, it could be different, but less than 50,000. So is it applicable that we can apply through it, or is it different than that? So the law says during probationary period, it doesn't say what happens after. And this is where the courts come into play. Maybe after one company or individual files a claim for this, the courts will justify and or determine and clarify what the situation is after probation.
Okay. I hope that gave you some insight, Jobu. I'll move on to the next question, which is from Marina. How can I book a consultation to discuss a legal matter with my employer? Um, not sure if this is to discuss with you, but Marina, if there's a follow-up question to this, if you could add that or give us some context, I think we'll be happy to we'll be more in a position to help you. I'll just move on to the next question, which is from Juhi. Can you discuss a little about Emiratization, since it's a bit unclear as to when should Emiratis be hired in comparison to the number of expats in the business?
I think the number used to be, it was anything above 50 employees have to have a certain percentage of Emiratis. That number I think has gone down. I'll also need to check what those ratios are, but there is a threshold. I'll have to check what that minimum is. So I think if I seem to remember the number 30, but I will double check that. So Juhi, if you wanna send me an email after this webinar, I'm more than happy to get you that response.
Sure. Thank you so much, Ahmad. I'm moving to the next question, which is from Rasil. After the probation period ends, should we create a new contract, or should the initial contract remain in effect if the terms and conditions are unchanged?
Short answer is one contract binds them all. So normally you would do a contract that says, here are your benefits, here are the terms and conditions. You are on a 1-month probation or 6-month probation. As soon as the probation ends, the contract continues unless either of the parties have either terminated or separated from the relationship. So you only need one contract. You don't need to redraft a new one. Just mention that there is a probationary period. That's it.
Okay. Moving on to the next question, which is, according to the new UAE Labor Law, what are the procedures for terminating an employee during probation? Additionally, can employers require the employee to reimburse visa expenses in this scenario?
So again, the procedure for termination is simply a letter just saying that effective immediately, you have been terminated. You can either be put on garden leave to serve your notice period, or we need you to work at the office. So depending on who's terminating or who's resigning in this situation, there is a minimum notice period during which the employee has to continue to serve for that duration. So if the employee resigns and is leaving the country, it's the 14 days and they can leave. That's the notice period. If they're remaining in the country, they do 30 days. For termination from the employer side, it's 30 days. So as an employer, you have a right to tell them, I want you to come to the office. You have to pay them for that time, but you have a right to tell them, I need you to come in, do your handover, do the work till the last day. If you tell them, I don't need you to come into the office and put them on garden leave, what's known as garden leave, you still have to pay them that period of time. So that's the one. Reimbursement, again, is during probationary period only for the costs. And again, I would try, if you're going to be filing for, what are the costs incurred, I would try with everything. Because like I said before, the courts are not going to grant you more than what you've asked for. So if you didn't ask, for example, for airline tickets and you paid for them, they will not grant you those. So I would put in airline tickets, visa costs, medical. If there's any relocation costs, put those in as well. You're not gonna, if you don't gain them, you're not losing anything by putting them in.
Okay. Thank you so much for that. I hope that answers the question for you. Moving on to the next question, which is from Nikhil. Regarding the annual ticket, if employee resigned, is it obligatory to release the unclaimed annual ticket, or the employer has the right to forfeit it?
So the determining factor is whether it's accrued and is owed. So if you pay the tickets every October or every December and he resigned in June, then technically no, he is not owed that ticket. The annual ticket. This is not the repatriation ticket. There's a difference between both. So if in your contract you say you are entitled to 1 ticket home per year, that's a contractual obligation, and it depends on when it is due for you to be able to say, I have to encash it for them. The repatriation ticket is a different one. That's an obligation under the law. So if the employee is resigning or you're terminating and they're moving back to their home country, you have to pay for that ticket one way. So again, is it due and has it accrued? If not, then no, you do not owe them this ticket.
Okay. Thank you for that. Moving on to the next question. And this is more like a rapid fire that we are having because there are a lot of questions. So I'm just jumping to the next question. So the question is the company required, like legally bound to take or medical health insurance to its employees? can the company assist them getting medical insurance, but the cost is incurred by the employees itself?
Yeah. So again, short answer is the employer or the company is obliged by law to provide insurance. They don't tell you the level of insurance that you have to provide. You can give them the basic one. That's part of the perks that an employee gets, but you have to provide them with one. That's the bare minimum. Now, I, for example, didn't like the insurance that we were provided under my company. So they created another category where I paid extra to get the primary one. But that's not an obligation on the employer. The employer just has to provide insurance. If everybody is on one level of insurance, then everybody is going to remain on that one. Some companies do, management is one, shareholders is another, employees, and depending on your level. So if you're a level C or level B, then the insurance goes up. The obligation is only to provide insurance. It does not state what sort of insurance. They can't force you to pay for the one that is provided by the company. But if you want something more, then you will have to incur it yourself, unfortunately.
Okay. Thank you for that, Ahmed. Moving on to the next question, which is, can the employment contract specifically state the arbitration as dispute resolution instead of this dispute scheme?
So we've been asked that question quite a few times. The answer is no, you can't. You can't opt out of the Dubai courts being the relevant authority. We have had similar situation where they said, oh, we will go to arbitration. I would tell you arbitration is actually not the right forum for it because it costs a lot more than courts. You have to pay for arbitrators, there's a procedure, so on and so forth. So even if you could, which you can't, but even if you could, I wouldn't recommend arbitration for such matters, for employment rights or employer rights.
Okay, thank you for that, Ahmed. There's one feedback of receiving the invites for the webinars a bit earlier. We have taken that, we have noted on this feedback. Thank you so much for sharing this with us. We will ensure that you get the invites a lot sooner. And yes, please keep asking your questions. And there's also our, LinkedIn platform that you keep following. You can get the updates there as well because we keep posting about the new webinars which are coming up. Now the next question is, just a moment. The next question is from Priya. Okay, so the question from Priya is, what are the rules or how we can select the students asking for internships from outside UAE?
There is no recommendation on how to do it. It really depends on the company itself. A lot of companies don't want to take interns at all. It really depends on the company policy. With my old firm and my current one, we actually encourage internships. There's no regulation. We just say that you need to make sure that if you are underage, that your guardian or one of your parents signs to say that we are okay with you attending. We normally used to give them just enough money for transportation, for example. There were no salaries, but we gave them transportation money. So it really depends from company to company.
Okay. The next question is from Prasant GS. What's WPS? What minimum percentage of the monthly salary should be transferred to the bank account?
So WS stands for Wage Protection System. So this was introduced quite a few years back to protect employees from not getting paid, basically. The answer is you cannot give a percentage. You have to give the full amount. We had a bit of an issue back in the day where a lot of the employees used to take an advance on the house loan, and that house loan got deducted from their salary. They blocked the company's WPS because you were receiving 10% less of your salary, the stated salary. So we had to change the wording in the contract to say that we will provide you with X amount on the side of the allowances so that the full amount that is transferred is always the same. Now, if you have, for example, granted a personal loan to the employee and you are being repaid on a monthly basis, WPS will flag that and you have to justify. So you say he has taken a personal loan or he has taken an advance on his salary. Here are the papers that you need to support it with. But the short answer is you should transfer the full amount every month, unless you have justifications.
Thank you for that, Ahmad. The next, there's some feedback from Abhishek Nair on greytHR. We will be sure to, share this feedback with our customer and product teams, and they will be in touch with you shortly. Thank you so much for attending this webinar. Moving on to the next question, since we are running, we are almost at 4:30. We'll just take a couple of more questions. If that's okay with you, Ahmed, then the rest of the questions we can take offline.
Yep, happy to do so.
Okay. Okay, so there's one question on, just asking you to throw some light on leave and other policy benefits for the independent contractor. That's contract for service, yes.
Yeah, so independent contractors is a bit of an interesting one because we've worded them in a way where sometimes we give them almost the same benefits as an employee, but in theory, an independent contractor who is somebody that is not employed under your company as an employee in the definition of the word, theoretically, it's a contract between you and them. If you decide you're not going to give them probation, you don't have to. Whereas with employment, you have to give certain benefits. So independent contractors is just a contract between you and individual. But like I said before, we have drafted contracts which look like employment contracts, have and grant the similar benefits as employment contracts, but there's no obligation to do that. That depends on the company and the employer themselves.
Okay. Thank you for that. So Marina has rephrased her question. The question is, how can I book a legal consultation to discuss a legal matter with my employer? Is there a process for that?
No. Legal consultation with me or with them to discuss certain aspects. Maybe I didn't understand it right. How can I book a legal
how can I book a legal consultant to someone employer? I think this is with her employer, with the employer.
I don't think there should be a procedure. I think it's just a matter of an email sent to HR and your line manager saying that I need to discuss certain matters about my employment. I would do it that way. Maybe even copy in head of legal if you have one, if there is one there. If you don't mind, Raki, there is a question that I would like to answer. Somebody asked, the gratuity calculation for DIFC and mainland, is it the same? Short answer is no. They have different rights and benefits. So the only two exceptions to the federal law, the federal labor law, are DIFC and ADGM, which is Abu Dhabi Global Markets. Those are the two exceptions, other than obviously government, semi-government, and Emirates, and a few others. But free zones the free zone law does not supersede the federal law, with the exception of DIFC and ADGM, which have the spirit of the federal law, but give different benefits and different rights accordingly. So that was the next question from Nikhil, that no, the free zone laws do not supersede UAE laws. They should be aligned with them.
Okay, thank you for sharing that, Ahmed. So Marina actually wants a consultation with you, Ahmed. So what I can do after this webinar, we'll share your email ID with her, and you can take this forward. Okay, thank you so much. Just one last question we'll take. So when should we pay the final settlement to an employee, after the visa cancellation or before visa cancellation?
So I would recommend, I mean, it depends again, if you're the employer or employee. If you're the employer, I would pay it on the date you're going to do the cancellation, because if you make the payment and they don't sign the paper saying, I have received my full entitlements and this is the ministry document, you have to file a case to get them to remove their visa. So we always used to say that have a check ready, even if it's a manager's check or whatever, and you hand it over when they sign the document. So at the same time, that way you get and you protect yourself as the employer, and the employee is also protected from delay in payments. So I would say it has to be simultaneous with the cancellation of the visa document itself.
Okay, thank you so much for that, Ahmed. And thank you so much, everybody, for joining us. I think we covered almost 90% of the questions, but there are still some questions pending. As I said, what I would be doing after this session, we'll share Ahmed's ID with you. You can connect with him directly. And we'll also be uploading this session on our YouTube channel. So maybe there's anything that you would want to rewind, just watch the session again, and that would help you. Okay, before we also log out, I would want to take your feedback. I'm going to launch another poll. Please help us, understand how did you like the session. There are 2 questions. You just have to tick mark one, response that you feel is most suitable. Okay, thank you so much. Again, as I said, there's a greytHR community. It's a knowledge sharing platform where you can connect with industry experts who would be happy to help you with your responses. And once again, thank you so much, Ahmad, for this session today. You certainly gave us a lot of insights on the new labor law changes, and I'm sure that helped everybody who joined us today. Thank you so much for taking out the time.
Thank you for having me, and thank you everyone for attending, and hopefully we'll speak soon. All right, take care.
Definitely.
Thank you.
Thank you so much. Also, everybody else who wants to connect with us on WhatsApp, there's a QR code which is there on your screen. You can scan that and connect with us on WhatsApp for anything related to our product, greytHR, or these webinar sessions that we have been having. We'll be happy to, connect with you there. So thank you so much once again, everybody, for joining us. If you have any more questions, you can connect with yasser.arafat@greytip.com, the email ID which is there on the screen, and we'll get back to you. Once again, thank you so much for joining us, and we hope to see you all in the next session. Thank you so much.
Thank you.
Thank you, Ahmed.